daily with lots of good information as well to keep you informed and up to date. So with that, I'm going to turn the presentation over to John Stolt to introduce our guest speakers.
Thanks, Crystal. We welcome you all that are in attendance this morning and appreciate you all taking the time. This really important topic that we've got to discuss today about what some of this new legislation that's come about as a result of the COVID-19 epidemic and how this is going to affect you as an employer. So let me take this chance to introduce our speakers for the day. From the law firm of RumbergerKirk. RumbergerKirk provides litigation and counseling services in a wide range of civil practice areas. They have offices located in Orlando, Tampa, Miami, Tallahassee, and Birmingham, Alabama. And our first presenter, Leonard Dietzen, is a partner of RumbergerKirk in the Tallahassee office. For more than 30 years, Leonard has concentrated his practice on the representation of private and public sector clients throughout Florida in all aspects of labor and employment law in both state and federal courts. After Leonard will be Kayla Platt-Rady, and she's an associate also in the Tallahassee office of RumbergerKirk, and she practices in the areas of employment and governmental and administrative law. She represents employers in private and public sector matters involving employment and labor issues. So I'd like to welcome our presenters this morning from RumbergerKirk, Leonard and Kayla. I'm going to turn it over to Leonard here in a second, as soon as I can flip over our slides.
Thank you, John. Can you hear me?
Sure can.
All right. Well, thank you everyone for attending. We appreciate the opportunity to address your members of the Florida Retail Federation. As John said, my name is Leonard Dietzen. I have been practicing employment law for over 30 years and understand how difficult for our members and how hard it is to adjust to laws as they come down. This particular law we're going to talk today is the Family First Coronavirus Response Act. If you could go to the next slide. There are several sections to this particular law that just passed, and this again was a bill signed on March 18th. It went into effect April 1st, 2020. So this is brand new, hot off the press. And employers are still trying to struggle on how to deal with it. And today we hope to answer questions and give information on how the paid sick leave works for both the emergency expansion of FMLA. That'll be the first section I will be covering. And then Ms. Rady will be covering the new federal paid sick leave law. There's interaction between the two laws, but they're not the same exact laws. And if we could go to the next slide, please. So before we get into the amendments of the emergency expansion of FMLA, I just want to give a basic primer of the Family Medical Leave Act. This was in 1993 it passed. It's a very technical law that we as risk managers and HR directors and business owners, we have to follow perfectly, because if you fail to grant leave, or if you take any employment action because of the request for leave, there's significant penalties, including one of the most expensive penalties is paying for the plaintiff's attorney. You could have a simple mistake on the FMLA and wind up paying 6 figures in federal court to a plaintiff's law firm. So one of the reasons why we want to get it right is to avoid winding up in the federal court, and also doing the right thing by our employees once we understand how this works. There's another reason why we want to really get it right, is because under this law, supervisors and HR directors, if they do things really incorrectly and willfully, they can personally and have some individual liability. So it's important to get to understand who is covered and how to implement the regular FMLA, because once you understand the regular FMLA, then you can easily jump into the amendment. So first, the FMLA applies to employers that meet certain criteria. So a covered employer is a private employer with 50 or more employees and 20 more work weeks in the current or preceding calendar years. And this includes joint employer, successor, and interest to a covered employer. So if someone buys you out, you have to add the math. Now, a lot of in the current FMLA Act, a lot of lawyers try to make your company or entity over 50 and find creative ways. But as we'll see under the new act, it's you know, I'll just jump ahead real quick. Under the new act, it's 500 or less, so it's significantly a different test. But for regular family medical leave, and we'll talk about that because that is still in place. The emergency leave is just one new type of leave that was granted. If you're a public agency, it's regardless of the number of employees. I had a city with 4 police officers and only 25 people. We edit policy manuals. In their policy manual, it said, because we're under 50, you do not get family medical leave. Of course, we had to correct that immediately because public employees and agencies, no matter what the size, it applies. And then you have some private and public secondary schools, regardless of the number of employees. So next slide, please. So only eligible employees who are entitled to FMLA, and this is again the regular FMLA. So that is one who works for a covered employer, again 50 or more, has worked for that employer for at least 12 months. That's a long time. The new law shortened this significantly, as we'll discuss. You have to work at least 1,250 hours during that 12-month period immediately preceding the leave. Again, that's a lot. That's going to eliminate most temporary people. So these are much higher definitions, which is why a lot of folks don't qualify, because again, you need 50 or more employees, and then they have to be there for a year. They have to have this amount of hours. There's another wrinkle that if you work at a location where the employer has at least 50 employees, it has to be within 75 miles of the home office. Like our main office is in Orlando, our law firm, and we have Orlando, Tampa, Miami, and Tallahassee. Now, Orlando has 100 employees, so they're absolutely covered. Now, in Tallahassee, we have 12 employees. So in Tallahassee, technically, our office is not covered by the FMLA because we're outside of 75 miles. Now, of course, we grant 12 weeks of family medical leave, but it's under our policy manual. And it's, again, you can do things under your policy manual and not wind up in federal court, versus when the FMLA applies and you don't get things correctly, you can wind up in federal court subject to attorney's fees. All right, next slide, please. So what does an employee actually get under the regular family medical leave? They simply get the right to take up to 12 work weeks of unpaid leave in a 12-month period. So this is not paid leave, this is unpaid leave. Now, the new law we're going to talk about is paid leave. This originally was discussed by Senator Hillary Clinton a long time ago during a campaign, and everybody thought it was way too radical to have paid leave. And here we are today with a virus, a crisis, and now we're going to be discussing paid leave. But under the current FMLA, the employee simply gets 12 weeks of unpaid leave. What triggers that? Each of these bullets: the birth of son of a daughter, placement of son of a daughter with employee for adoption or foster care. The next couple ones you have to pay attention, because this could be in effect right now and intersect with the new type of leave. To care for a spouse, son, daughter, or parent who has a serious health condition. And then for a serious health condition that makes the employee unable to perform the essential function of his or her job, and for any qualifying exigency arising out of the fact that a spouse, daughter, parent is a military member. There's a lot of different sections about military. Military are treated special under FMLA. They can get up to 26 weeks. All of this should be in your policy manual on who gets it, how they get it, and what type of notice they have to give you. Typically under the regular family medical leave, an employee would give you 30 days notice. We'll talk later under the new, and that's if it's foreseeable. Obviously, if they're in a car accident, they don't have to give you 30 days notice. So certain events trigger notice. The new FMLA we'll talk about later is going to be only 7 days notice. So here's the new law. It's emergency FMLA expansion. I call this FMLA plus, and the plus is really money. Never before has FMLA come with pay behind it. So we'll go and describe who's entitled to this next. All right, so an employee who is employed for at least 30 calendar days immediately prior to the leave that when it begins. So when if they request leave today, you go back 30 days and say, were they on the payroll for those 30 calendar days? That's much easier to meet than 1,250 hours under the regular FMLA. So this is going to capture many more employees, and it was intended to capture many more employees. This was intended to capture new hires, and we'll see more because employers are, it's a lot easier. So if you could go to the next. So who is actually now an eligible employer? It's now amended to fewer than 500 employees. Well, that covers most businesses. As you know, most businesses in America are small businesses. I was on the board of Chamber of Commerce. I would say 80% of our Tallahassee Chamber of Commerce members had less than 20 employees. So this captures many, many people. If you have fewer than 500, and that's 5, 10, 15, you're now under only the Emergency Family Medical Leave Act, not the whole previous leave that we discussed for all the other reasons. It's going to be a very narrow reason. And then for public employers, regardless of the number, it applies. All right, so when does it not apply? So if a private employer has 500 and more employees, you're not covered by the expanded FMLA. So you're not going to be in the situation where you have to pay people for various reasons to take FMLA. This is some relief for big companies. So if you're a private employer with 500 or more employees, you are exempt. You still have to understand, obviously, the FMLA, and employees are still demanding this paid leave. I have several clients who have unions, and the unions are asking to bargain, if they're large, to get this inside of their collective bargaining agreement. And that's just discretionary if you're over 500. All right. So there is a way to calculate what is fewer than 500 threshold. It's at the time the employee takes a leave, you employ fewer than 500 full-time and part-time employees, and that includes. We'll go to that includes employees. Full-time, part-time, including employees on leave, temporary employees, jointly employed by you and other employers, day laborers, which is an interesting addition supplied by a temp agency. The only thing it does not include are independent contractors. So if you're near 500, you really want to get down to the nitty gritty and find out who's on your payroll, whoever's handling your payroll, your CPA or your accountant will help you make that decision. Now, there is an exemption for certain employers for the expanded emergency FMLA. And so this will help some of our members. An employee may, and it says may, the key is the first bullet, the employer may elect to exclude the following employees from application expanded FMLA, and that's if they're a healthcare provider or an emergency responder. I represent the Florida Police Chiefs Association, and of course they have many people that are exempt from this. Now it's it's permissive. The regulations Department of Labor has suggested in the second bullet, to minimize the spread of COVID-19, they want you to be very judicious when determining healthcare providers and emergency responders are exempt from this new law. Basically, be careful and make the call. I read some examples where they said if there's a secretary at the office of the hospital, that's one thing to grant her or him leave. If there is an RN nurse and they have issues with why they need to leave, that may be a harder call, and you just may need them, and you can deny that. It's up to the employer. So who is a healthcare provider? Of course, every law has many definitions, and it's pretty expansive, as you could see. A doctor's office, pharmacy, hospital, clinic, healthcare center, post-secondary educational institution that offers healthcare, a med school. The list goes on and on. Retirement facility, home healthcare providers. I have had several calls from retirement facilities where they just can't afford to let people go home. They're on overdrive staff because everyone's on lockdown. So they're having great difficulty, and they are allowed to exclude their employees. Okay. Also excluded are those individuals employed by the entities we just discussed above, the healthcare entities, if they contract with any of these folks, institutions described in previous slides where the individual services support the operation of the facility. So you got to look at your contracts, and they also, those companies can exclude them. Provide medical services, produce medical products. Right now it's the mask or the ventilators, or involved in making of medical, COVID-related medical equipment, tests, drugs, vaccines, diagnosis vehicles, or treatments. Many companies in Florida are online doing this right now, and so they may be excluded. And I promise you we'll get to what they'll be excluded from. We have to go through all the technical definitions. I can promise you the plaintiff lawyers on the other side will go through these definitions and try to find out where you're getting this wrong. So we want you to get everything perfect so that you never wind up in federal court discussing the Emergency Family Medical Leave Act. That's the whole goal today, is to keep everybody informed so that we can check all the right boxes and get this correct. Now, emergency responders who may be excluded, and you can just see a list of all of them, and obviously police, firefighters. I think HR directors are firefighters. I mean, late this last month, it's been incredible to see all my clients handling a crisis and switching to online work, getting IT to work with HR, trusting people to work at home, not knowing whether they're working. It's been amazing to watch how businesses have flipped the switch overnight, and HR has really stepped up to the plate. So those are the people who are excluded, not many in your membership, but if you're wondering why are police out there, that's why they're out there. They have to be out there. So helpful definitions before we get into what they actually get is a public health emergency is an emergency with respect to COVID-19 declared by federal, state, or local authority. Counties have different ordinances, states all have various degrees. It felt like every other day, the governor was coming out with executive orders for Florida, and obviously we have federal orders, state of emergencies declared. We meet this definition hands down. Telework is mentioned in the rules, and so what is telework? Obviously, when employer permits employee to perform work at home or location other than a normal place of work for normal wages. Now, when a person wants this emergency leave, they're not able to work or telework. Lots of employers have allowed people to go home and work, but we'll find out it's really related to childcare if they cannot do both. So unable to work or telework is when you actually have work for the employee, but there's a qualifying reason that prevents you, the employee, from being able to perform that work. It's important to know if you send employees home and lay them off, or if you have a reduction in force, or if you furlough employees before they ask for this paid leave, they're not entitled to that leave. The key is not to have someone ask for the leave and then 20 minutes later decide you're going to lay that person off. The timing of that would obviously look terrible. So if you're in the process of deciding to furlough or lay off employees, have great documentation of when you're doing that, why you're doing that, and whether it's across the board or how you're just making those decisions, so that then one day you'll justify it. Because even a person on leave, if the doors are closed, the doors are closed. You don't have an obligation once you're unfortunate, you have to close the doors until this crisis is over with. All right, another definition that you need to know, because the emergency leave applies primarily for daycare situations. So the regulations just say simply if you're unable to care for your child, and they never really define it, but if you dig deep into the FMLA, it's son or daughter means biological, adopted, foster child, stepchild, legal ward, or child of person standing in local parentis who's under 18 years of age or 18 years of age and older and incapacitated of self-care because of mental or physical disability. So I've had a few people say that's not really their son or daughter. And you got to go back to the original FMLA to dig out the definitions. It's a very liberal definition. I've told many clients it's not time to get technical. We are allowed to ask for, just like under the regular FMLA, there are forms on the Department of Labor for the regular FMLA that allow you to ask the healthcare provider, what is the underlying condition, how long will the condition be, and you get proper paperwork. For this leave too, and we'll go to the next slide. You're probably wondering, when is he going to get to the actual leave they're entitled to? Well, here is the most important slide for the FMLA part, slide number 20. So you're entitled to this paid leave if an employee is unable to work or telework, and we already discussed what that is, due to a need for leave to care for his or her child who is under the age of 18 of age, because two reasons only. Remember, there's a lot of reasons under the regular FMLA, but just these two reasons. The child's elementary or secondary school or place of care has been closed due to a public emergency. Now, for that one, we know all schools in Florida are shut down. It's just a fact. but it says elementary or secondary schools. Again, this is not college. Some people are saying, well, do you need proof of that? You really don't need proof. We know schools are closed for that. You can go on any school's website. Now, Department of Labor is saying you need to have a nice paper trail of why they're taking leave. You can go on the child's website and they could print the schools are closed. It's that simple. The next one is the child care provider of the child is unavailable due to a public health emergency. There's some suggestion you could simply get an email from the provider saying that they're no longer in business until this crisis is over. So if they get that, what do they get? And this is the next slide. So if they have child care issues, and we're just going to say child care issues, because schools are closed, they're at home, they're trying to telework, and they have 3 kids. And my wife's a teacher. If you're in middle school, you have 6 teachers. So if you have 3 kids at home or middle school and high school, you potentially have 18 classes that they're taking a combination of virtual and downloading packets. And it's from many of my friends are telling me it's a nightmare trying to keep up with that many teachers. So anyhow, what do they get under this emergency? They get the first 10 days is unpaid leave, but the employee can use vacation, PTO, sick medical leave accrued, but the employer can't force them to use, so you can't mandate they use it. So the first 10 days is unpaid. Remember, the first 12 weeks of regular FMLA, I call it non-childcare FMLA, is unpaid. So here it's just the first 10 days. Now, Ms. Rady will discuss later, there's another act, the Paid Sick Leave Act, that will cover the first 10 days if you meet certain technical definitions, but child care is one of them. So while it's unpaid right now under this law, the other law comes back, and we'll explain later that helps cover the first 10 days. The key is you can't mandate them how to use their leave. Of course, if they have leave on the books, 99% of them are going to want to be paid for the first 10 days. So the next 10 weeks, the employer must pay, and we'll show you how much on the next slide. It's not 100% for the emergency family medical leave. So if someone wants family medical leave, the child care emergency family medical leave, the amount is no less than 2/3 the regular rate of pay of the number of hours they're normally scheduled to work. So it's not 100%. Because it says no less than 2/3, there are a number of employees asking the employer to kick in the extra third. That's discretionary. What I have heard is the government is going to repay through tax credits only the 2/3. So it's up to the employer of how generous they want to be. Most can't afford it, so most will do the 2/3. That's mandated by the federal law, and then through a series of payroll tax credits, they'll get reimbursed. That's why excellent records are needed at all times for the type of leave they're asking for, exactly when they go on it, what is their exact regular rate of pay, and what do they normally work. Now, if the most you can pay, if they're 2/3, if they're making a lot of money, the most they can receive is $200 a day, or a total of $10,000 aggregate for the 10 additional weeks that they're on paid leave. So under this law, again, it's 12 weeks total. The first 2 are unpaid. The other law may apply, and they can get paid under that. And then under this one, the emergency family medical leave, it's up to $200, $10,000 aggregate. I believe in you'll have to get with your accountant, because I won't give tax advice, but you will be given credit for this payment, so it won't be a burden. My public sector employees who do not get a credit, this comes out of their budget, and of course it was never planned. So for some of my smaller school boards, this is quite an issue because, as you know, everyone is at home, and many people are taking this leave. Okay, if you have an employee that has a varied hours and they work different times and you just don't know even how to average it, you basically look back over the last 6 months and you figure out what type of hours they worked. And again, this is going to have to be on an Excel sheet, and you're just going to have to calculate what is the running average. Unlike wage and hour law, you actually include if they had vacation time and if they had leave, holidays, you actually include that as hours worked. That's not what you do when you calculate overtime. So they're trying to be as generous as possible to the employee. So if you have any doubt on this law, err in favor of the employee, because we don't want to get caught shortchanging and wind up in federal court, taking depositions and spending a lot of money on lawyers. Now, as we discussed, this is only if your child's school is closed or you have daycare issues. So when the executive order, I think it was 2020-91 came out, and they said 65 and older and folks with serious health conditions have to stay at home, I had a number of employees wanting this paid leave for under the emergency family medical leave, because they said, well, the governor said I have to stay home and I need, I want to be paid. And again, it was 65 and older or serious health conditions. It had nothing to do with childcare. I had probably 50 calls in those 2 days following that executive order. So that does not count for the emergency FMLA. Now, Ms. Rady will discuss, it may cover under the Paid Leave Act, but again, if you're 65 or older, that's not a day, that's just not a triggering act under this. That caused a lot of confusion throughout the state, as is every executive order. As soon as the executive order is issued, the next day they came out, or 2 days later, with a question and answers saying we really didn't mean stay at home for everyone. There's first responders and other exceptional businesses, and so other people were allowed to come back to work. Now the next question comes, can they take this in pieces? And the answer is yes. Like under regular FMLA, if you only need 3 hours a day, and some people are on dialysis, they need 3 hours a day, or chemotherapy 3 hours a day, you don't need the full day. You can allow, the employer can allow them to have the paid leave for intermittently. We have, and you can be creative as you want. We have folks who normally work in our office from 8:30 to 5. I have a paralegal who has 2 kids at home, both with numerous teachers, and we've altered her hours from 7 a.m. to 11 a.m. and then she comes back to work later in the afternoon, and she's able to manage the full workday, and we just work around it because she's actually, the homeschool teacher during the middle of her day and doesn't need paid leave. But if I've had several calls with 4 kids at home and they just can't get to it. And so it's hard. And so never challenge the employee if they say, I cannot work at home because of my childcare situation. We've had a few people say, just go in the other room. Just go in the other room with your laptop, do the best you can. Give them the paid leave. Never dispute unless they don't have children or they don't meet the other qualifications. This is not a time to bargain with employees. about whether they need it or not. Now, you can ask for proof whether their daycare is open or not, but if they say they can't work and they want this leave, again, it's not a time to get too technical with employees, because I believe a jury 2 years from now, they're all going to remember how terrible this was, staying at home, and the employer is just going to get punished for being too technical. I'm advising all my clients to be very flexible and very generous when they're interpreting these new laws. All right. Now, under the regular FMLA, you still provide health insurance. If the employee has a deductible, they still have to pay that portion, and it just rocks along for 12 weeks. And the good thing about the FMLA is they're entitled to their job or substantially similar job back. So it's kind of a way to say, okay, you get 12 weeks and we're going to keep your job. If you don't, that's when there's a retaliation claim, and that's when the lawyers jump in and get involved. And again, it gets expensive. Now, there is a provision, an exemption, that to restore a position under the FMLA will not apply if the employer employs fewer than 25 employees, providing the following conditions are met, and again, have to meet all of these. The position is held by the employee when leave commenced no longer exists due to the economic condition. Again, we discussed earlier, if you lay people off, if you furlough folks, if all of a sudden now another executive order comes out and says you're not an essential business, then you have to close your doors. So you don't have to owe them a job if financially you're not able to keep your doors open. Other changes in operating conditions of the employer that affect employment are caused by public health emergency during paid leave. Many of those. The next one has to be met also. You make reasonable efforts to restore the employee to equivalent position held when the leave commenced. So you're trying to get them into equivalent job, benefits, pay, and terms and conditions of employment. So you try to find it and you just can't. If the employer's reasonable efforts fail under the second item, then the employee must make reasonable efforts to contact the employee if and when equivalent position comes available during the period beginning on the earlier of the date on which the qualified need related to the public health emergency concludes. So when this mess is all over with, when we can open the doors and the economy turns on again, then you can call them, or the date that is 12 weeks after the date which the FMLA commences. So you're essentially going to need a spreadsheet and have to keep track of who asked for leave, who is on leave. Every time you make a decision to cut further employees, you need to have that specific records of who and when you made those decisions and why you made those decisions. Obviously, most of them are driven by revenue. So my final comments on this, the documentation is the key. If they want child care type leave, that is permissible. Under the new emergency paid leave, again, they get 2 weeks not paid and then 10 weeks 2/3 paid. And remember the old FMLA, follow all of those guidelines. At the end of the presentation, there's great government links that will help explain all of this if you have any different, really difficult questions. And of course, as always, consult your lawyer and make sure you get this right. Our goal is to not have any of our members being sued, and comply with the law and do the best you can. Most laws take a year to figure out what they are. Again, this one's only 16 days old with respect to the implementation. So I think if you follow our PowerPoint and the links at the end, you're going to have a head start over most employees. And with that, we'll go to the next section, which is the Emergency Paid Sick Leave Act, and Ms. Kayla Rady will go through that portion. Are you there, Kayla?
Kayla, can you hear us?
Okay, I'll start and we'll wait until Ms. Rady's on. We're in different locations, so I'm not sure what's happening. So again, the Emergency Paid Sick Leave Act, we need, again, to have definitions. Again, a federal law, you have to know every definition. Why do we have to know? Because we have to be perfect. Again, why do we have to be perfect? Because we're trying to avoid, A, we're trying to do the right thing by our employees, and then B, we're trying to avoid winding up on the other end of the lawsuit. So a healthcare provider, for purposes of determining individuals who are advised to self-quarantine due to concerns related to COVID-19 for paid sick leave, is a licensed doctor of medicine, a nurse practitioner, or other health care provider permitted to issue a certification for purposes of FMLA. I can tell you over the years, I've been dealing with FMLA for like 20 years, it's almost anyone, almost anyone. You know, you really have to be careful of saying that's not really a healthcare provider. So make sure you're not getting too technical. Like if it's a nurse practitioner, they're allowed. You go under dol.gov and you'll see it's a very broad definition of healthcare provider.
Can y'all hear me?
There you go. Yes.
Oh, I have no idea what happened. Sorry about that. So y'all can hear me now, right?
Yes. I just went through the definitions of healthcare.
Okay. Yes. And so for this definition of healthcare provider, I wanted to include this slide because Leonard was previously talking about healthcare providers who are exempt, and that definition is a little bit different. That was a way broader definition. We're talking about employees who are healthcare providers. This is specifically talking about if it's your doctor or nurse practitioner who has advised that you need to self-quarantine. So I just kind of want to make that distinction when I'm talking about this next 2 weeks paid sick leave. Okay, John, you can go to the next slide, please. Okay, so an employee is eligible for up to 2 weeks paid leave, and there are 6 reasons that they can get this 2 weeks paid sick leave. And depending on the reason, depends on whether you get your full regular rate of pay for up to that 2 weeks or 2/3 of that regular rate of pay. So the important thing to note is an employer has to provide this paid sick time if the employee is unable to work or telework, meaning work remotely, due to a need for the coronavirus because of these 6 specific reasons. So the first 3 reasons we're going to lump together, and then we'll address the next 3 after that. So the first reason is if an employee is subject to a federal, state, or local quarantine or self-isolation order related to COVID-19. This includes shelter-in-place orders and stay-at-home orders. The key here is to remember if the employee is unable to work or telework due to that order. So there is a chance that an employee could still telework, and if that was the case, you wouldn't necessarily have to pay them the paid sick time. The second reason is if the employee has been told by their healthcare provider, in this case, if they've been told by their doctor that they need to self-quarantine due to concerns of COVID-19. And the last one is if the employee is experiencing these symptoms of COVID-19 and is actively seeking a medical diagnosis. Under these 3 reasons, and we'll get to it a little bit more detail, you get paid your normal rate of pay up to 2 weeks or 10 days, 10 working days rather. For the next 2 reasons, again, if the employee is unable to work or telework because the employee is caring for someone described in number 1, and number 1 is if there's a self-quarantine or, a quarantine or self-isolation order, or if an employee is caring for an individual that's described in number 2, which is their doctor has told them to quarantine due to COVID-19. Or number 5, which should sound identical and very similar to what Leonard just explained, because it is, if an employee is caring for their child because their child's school is closed, their place of care is closed, or the child care provider is unavailable. So as Leonard mentioned, all schools are closed. Just because there's virtual learning doesn't mean that schools aren't closed. Places of care can include pre-K, daycare, before and after school programs, summer camps, and child care providers can include your grandma, a nanny, a babysitter, your neighbor, if those people were the ones that typically took care of your child. And then the last exception, or the last qualifying reason, is for eligible employees. And really this is a catch-all, and it says employees are experiencing substantially similar conditions as explained and specified by DOL. I can tell you right now, Department of Labor has not identified anything yet. It's just something to keep be aware of, because this law, as Leonard mentioned, is constantly changing. They're constantly adding new stuff to it. It did just go into effect on April 1st, so it is pretty new still. So it looks like there might be a question, I don't know.
Yes, Kayla, there is a question. What if an employee who makes deliveries to other businesses doesn't feel comfortable performing their duties because of what's going on? Would the employer have to give them any of these paid leaves?
So it has to be one of these 3 or one of these 6 reasons they're unable to work or telework. So if it has nothing to do with one of these 6 reasons, if they're just simply uncomfortable, I would say no. And Leonard, you can correct me if I'm wrong on that, but no. So if the employer has work available, then you don't have to give them the paid sick leave. If the employer has work available, but they are unable to work or work remotely because of one of those 6 reasons, then you do have to give the paid sick leave. Does that make sense?
Yeah, I agree with that. And we've had several companies saying their cashiers don't feel comfortable. Their pharmacy techs don't feel comfortable. Well, that's not a part of the Federal Paid Leave Act. Many people don't feel comfortable going out, but that's their job duty. Many of my police officers don't feel comfortable being out there, but if the job is open and the duties are there and you don't meet one of these criteria, you still have to go to work. And then it's up to the employer how they want to take safety measures for that employee, because then the employee may try to be a whistleblower or something, saying you're not helping them take various measures. But you have to hit all of these or you just don't get paid.
Yes, exactly. So one of the key distinctions of the Paid Sick Leave Act that's different than what Leonard discussed regarding FMLA Plus is it does not matter how long the employee has been employed. So they could have been hired yesterday or a year from yesterday or 30 years ago. It doesn't matter. They are automatically entitled to the paid sick leave. All right, John, if you want to skip to the next slide and then go to the next one. Thank you. Okay, so which employers must comply? This should seem very similar because it is. If you are an employer who has 499 employees, you must comply with this. How do you calculate that? It's the same exact calculation as what Leonard described in the first section with FMLA Plus. Okay, next slide, please. And again, if you have 500 or more employees, the Paid Sick Leave Act does not apply to you. You don't really have to worry about any of those 6 reasons. You don't have to give any of your employees paid sick leave under this act. Again, like Leonard said, you can elect to do it, but you don't have to. And I kind of already discussed this. How do you calculate the fewer than 500 employees threshold? It's the exact same calculation that Leonard discussed in the FMLA Plus. You include all your full-time and part-time employees, but you don't include your independent contractors. All right, next slide. Also, as Leonard discussed earlier, your healthcare providers, and this does include that very broad definition, and your emergency responders, which includes that very broad definition. You can exclude those people from the 2 weeks paid leave. Again, DOL wants you to use that same guidelines when looking and evaluating whether those employees are excluded or not. Use it judiciously. Okay, next slide, please. Okay, so what is this paid sick leave? So essentially it's up to 10 working days. If you have and it's your normal hours regularly scheduled. So if you have an employee that only works Monday, Wednesday, Friday, then they're really only going to get up to 6 working days. They're not going to get up to 10 working days because they're not normally scheduled to work in a 2-week period for 10 working days. They're only scheduled to work for 6 working days. So for full-time employees, and the Department of Labor looks at that as generally 40 hours, you can get up to 80 hours, and it's capped at 80 hours. So if you have a full-time employee that typically works 50 hours a week, then they're going to get 50 hours for that first week, and they're only going to get 30 hours for that second week. It's capped at that 80 hours. For part-time employees, you take the average over a 6-month period. You take that 2-week average starting on the day they took that leave. The intermittent paid sick leave, again, this is kind of similar to what Leonard was talking about in the FMLA Plus. It is at the option of the employer. The employer can agree to allow the employee to take paid sick leave. So say you have an employee who is homeschooling their child, and they're unable to telework for hours 10 a.m. to 2 p.m. So they can't work for that time. That is a qualifying reason. You can give them the paid sick leave for that intermittent time and agree to allow them to work the rest of the time and get paid normally the way they work there. If that makes sense. Okay, next slide, please. Okay, so what is this amount of pay? I kind of mentioned it earlier. For employees who qualify under reasons 1, 2, or 3, and again, those are if you've been ordered by the government to quarantine or self-isolate, if you've been advised by your doctor to quarantine or self-isolate, or you're experiencing symptoms of COVID-19 are actively seeking a medical diagnosis, then you get paid your regular rate of pay or minimum wage, whichever is greater, for the number of hours you're normally scheduled to work. This is capped at $511 per day and $5,110 in the aggregate. All right, next slide, please. For employees who qualify under 4, 5, or 6, and again, this is an employee who is caring for an individual who's subject to an order to quarantine or self-isolate, or caring for their child because their school's closed, their child care is unavailable, their place of care is unavailable, then they only get 2/3 the amount of the regular rate of pay or minimum wage, whatever is higher. And this is the exact same, 2/3 amount of regular rate of pay is the exact same thing as under the FMLA Plus that Leonard just discussed. So for those first 10 days under the FMLA Plus where you don't get paid, this paid sick leave could kick in. Again, this is capped at $200 a day or $2,000 in the aggregate, which is exactly the same as the FMLA Plus. Okay, and so if your hours vary, this is the same calculation as Leonard described earlier. You take the average number of hours for a 6-day month period starting on the day they took the paid sick time. And because this applies to employees who are been employed less than 30 days, if they were employed yesterday, you would just take an average of the reasonable hours you expected them to work at the time of hiring. Next slide, please. So you do have to put notice of this Paid Sick Leave Act. And because some regular business locations are closed, the way that they say it is it must be in a conspicuous place on the premises. But because on the premises might not actually technically be available, they have also, they being the Department of Labor, has said you can email this to employees, mail it to employees, or post it on an internal employee website, which is what we recommend. You still have to do it, even if you are exempt, which we'll get to, you still have to put this notice up and let the employees know that this is something that they have as an option. And this is really good. The Secretary of Labor has prepared a notice that they have recommended you can use. It's an approved notice. You can use that notice, put it on your employee website, or create your own, but they do have one that you can copy.
Hey, Kayla?
Yes.
I have a quick question. So would you advise an employer to have the employees sign that notice to keep on file if possibly they don't have an email address to give them or something like that? Would that just kind of help state their case that the employees read it, they understand it?
Leonard, you can tell me if you have a different take. I would say no. Leonard, do you have something else to say, add to that?
Yeah, it's just like your regular minimum wage poster or your FMLA poster or your OSHA poster. You have to, you just have to prove that they had notice. Certainly, many people put in their policy manuals these new laws, and then when it becomes in your policy manual, now this particular law expires December 31st. So most people aren't revising their policy manuals, but if you put it in your policy manual, you would have them sign a statement you read the revised policy manual and understand all your terms. The notice requirement is just to get the information out there to them. It's a difficult decision on whether or not you email it to them individually or you just post it internally in your office. For my school boards who went 100% virtual for teachers, we couldn't just post it at the school principal's office with all the other posters. So we made a decision to push it out to all of the teachers, and we just had a mass email, and the proof of the email is good enough to show they got it. It's not it wouldn't be wrong to get them to sign it. It'd probably be not a bad practice at all. Not required, and most don't do it for any other ones. But this probably is a different law that if you want to ensure your employees are educated, it wouldn't be a bad practice.
Okay. So moving on, so this paid sick leave terminates as soon as the need terminates. So you will stop paying the sick leave immediately beginning with their next scheduled work shift following the termination of that need. So if the quarantine order is lifted, if they are no longer experiencing the symptoms, then the paid sick leave immediately terminates. And as an employer, you can require your employees to give reasonable notice in order to continue receiving that paid sick time. Next slide, please, John. And we kind of already touched on this. Again, this 2 weeks paid sick leave is available immediately, regardless of how long they've been employed. You cannot require your employee to use other paid leave before they use this paid sick leave. So if they have accrued time, you can't require them to use that first. And this won't carry over into the next year. As Leonard just mentioned, this ends on December 31st. Next slide, please. Next slide, please. Okay, exemptions under both the FMLA plus and the paid sick leave. Next slide, please. So, under the paid sick leave, remember there's that providing child care qualifying need. That is the same as the FMLA plus one. If you employ fewer than 50 employees, so 49 employees, you're considered a small business. And if you have an employee who is under this child care related paid sick leave or the FMLA plus paid sick leave, and you think that providing that qualifying reason would jeopardize your business, and you're very concerned, then you can have an authorized officer of your business determine the following things. So this authorized officer would have to determine that the leave would result in your small business expenses and financial obligations exceeding available business revenues and cause the business to cease operating at a minimal capacity. They would also have to determine that the absence of this employee or employees, if it's a bunch of employees taking care of their children and are unable to telework, that the absence of the employee requesting the leave would entail a substantial risk to the financial health or operation of the small business because they have specialized skills, they have specialized knowledge of the business or specialized responsibilities. And there are not sufficient workers who are able, willing, and qualified, and who will be available at the time and place needed to perform the labor or services provided by the employee requesting the paid sick leave or the FMLA plus. And these labors or services are needed to operate the small business at a minimum capacity. So if you are a small business, there is an exemption that you can qualify for, provided that those three reasons exist. The Department of Labor does not want you sending any sort of document showing that you're a small business. They don't want to see anything like that right now, and they will address in more detail the criteria that we just addressed. Again, this is new law. It's continuing and changing each day, but that's essentially the exemption in a nutshell. And what Leonard kind of mentioned is earlier is that we recommend, in order for you to track the exemption and the tax credits, that you keep records. So you keep records of the employee requesting the leave, the dates they requested the leave, the reason they requested the leave, and all you simply need is a statement from the employee that they are unable to work because of whatever that qualifying reason is. You don't necessarily need a doctor's note. Some stuff you can track down, like Leonard said, you can go onto the school website and see that the school is closed, but essentially we're just going to take the employee at their word.
Kayla, let me intercede at one point on that. If one of the reasons is not childcare, if it's because you have a COVID-related illness, what I've told employers is you can ask the employee for a medical proof of that, but don't insist, like under the former the regular FMLA, you would want a certified record from the doctor and you would evaluate it. You can get a second opinion and you can go through this whole process. In this day and age, you can barely get to a doctor to get any certification or get any proof. You just simply tell the employee, send me proof as soon as you can when things calm down. Ask your doctor if it's related to an illness and not childcare. And don't give the employee a hard time because those are the cases that the plaintiff lawyers love. So it's not the time to be perfect on medical records. I've told all of my employers, don't hassle them. I've tried to get an emergency prescription for my wife, and it was like an act of Congress to get to my doctor, who I'm actually friends with, but he was overwhelmed. So this is not the time to be perfect on getting that medical record. You can request it, but don't deny leave because the doctor is 2 months behind. So that's my only caveat when it comes to a medical condition. Thank you.
Yeah, I totally agree with Leonard, and that kind of goes right into the next slide. You know, if the reason is because of a quarantine order, simply document the name of the government entity that issued the order. If it's due to a doctor advising the employee not to go into work because of they're experiencing COVID symptoms, simply ask for the name of the doctor. If it's due to the child's place of care or school being closed, simply ask for the child's name and the school, place of care, child care provider's name, and a statement that the employee has no other suitable person, there's no co-parenting, there's no other person available to care for the child. You don't need to go into super details with your record keeping. And why keep the records? This is very important to show if you intend to claim a tax credit or if you want to get an exemption. And as Leonard mentioned, private employers are eligible for tax credits. Public employers are not. We're not going to give you tax advice, but you can consult IRS forms, instructions, and information on how to get those tax credits. And these are just helpful resources available at the Department of Labor. They are being updated weekly, if not daily. They have frequently asked questions. They have the paid sick leave notice we mentioned earlier, calculation guidelines. Can y'all hear me?
Yes.
Okay. And that's it. So if there's any other questions for Leonard and I, let us know.
For those,
Kayla, Crystal, just a quick question. What if an employee has to take care of a sick elderly parent, maybe a parent that's come down with COVID-19, and they need to be able to care for them kind of around the clock? Does that apply under any of these, exception of a child? Could it be an elderly parent, or does that not apply?
So if that individual, it's kind of hard to hear you, but if that individual has been advised by their doctor due to COVID-19 concerns to self-isolate or quarantine, so again, like if they're regularly inside that employee's home, if they're an immediate family member, or they have some sort of relationship to that employee and they depend on that employee for care, then it would apply for the paid sick leave.
Yes, I think that's number 4. It's employee is caring for an individual who is subject to an order as described in number 1. So they are caring for a person. So they would get the 10 days. Now, then you would have to go back under the regular FMLA because it's not a child care issue. So then you would just go under the regular FMLA, and then they would get the unpaid leave if they're caring for a relative, and that meets the definition of a relative. So it's a little tricky. They would get the first 10 days. And I think it's 2/3 because it's under the 4th reason, and then they would get unpaid for 10 weeks. Good question.
if anyone else has any questions, either type them in the chat feature or just jump on right now and ask them. So we'll take one last call for questions. And while we're waiting for that, on behalf of the members of the Florida Retail Federation, I just want to thank Leonard and Kayla for this information today. This is the one area that we've really had a lot of challenges and questions with from our membership, and we just so appreciate this. We have recorded this, so look on our website if you want to refer back to it, or if you have others that weren't able to attend today to take a look at this. And there's other information and links on our website. If you want to consult with an attorney on this, the information for Leonard and Kayla is here on our screen. So you could be happy to either, I'm quite sure, call them or email them, and they'd be happy to, respond and help you all out. So,
and John, one final thing, John. We have prepared a cheat sheet, which helps employers basically understand the entire thing on one page for FMLA expansion and the next page for the Emergency Paid Sick Leave Act. And we will send that to you, and you could post that on your website for your members. It's a great guide of quickly answering phone calls. We've had a number of clients really enjoy this 2-page document, and we'll provide that to you for your members, and it'll make it a lot easier to understand. And thank you for the opportunity to speak with your members.
We appreciate it very much. And for those of you on the webinar, next week we're going to actually have an accounting firm talk about taxes. And so I will ask them to address some of the things from an accountant standpoint that we have to do with the reimbursement of this piece. So please look out for information on that. And Crystal, do we have any last questions? Okay, if not, we thank you all for your time today, and we hope you all are doing well and surviving this very challenging time in the business world. Have a great day.